Good afternoon, Pal ma'am. How are you?
I'm fine, man. How are you?
Good, good, good.
Again, we are meeting online only.
Yes.
Yeah. Okay, Padma ma'am, we can start now.
Yes, Navjot.
Good afternoon, ma'am. So we welcome Dr. Kiran Rai. She is an associate professor of law at MNLU Mumbai. She has a rich experience of teaching graduate and postgraduate students, as well as guiding them in their research projects. She has many awards and recognition to her credit. Besides having authorized numerous research papers and a few books, she has done extensive research in the areas of corporate governance, insolvency and bankruptcy code, and law for surrogacy. She has mobilized funds and collaborated with prestigious government organization NCW, NHRC, Competition Commission of India, and IBBI for organizing workshops and seminars. She is a member of Network of Indian Competition Experts formed by CCI. She is the director of the Center of Training and Research in Corporate Regulations and faculty advisor of the student run journal on corporate law and commercial regulation. Ma'am would be taking up the topic of insolvency and bankruptcy code 2016. So over to you, ma'am. And if participants have any questions, please post it on the chat box. We'll take it up at the end of the. Thank you.
Thank you so much. So, though the session is of only 1 hour, but the topic is so interesting that I don't feel the challenge taking this post-lunch session. So, actually, the topic given to me was use of technology in insolvency law. So, I had focused on the use of technology and how we can use that technology in insolvency law. But while giving the introduction, it was said insolvency law. Nevertheless, I would just like to know before I start my session, how many of you have read insolvency law IBC 2016 or had some exposure to IBC 2016? Because if we understand the overview of insolvency law, then we can anticipate where technology, if it is incorporated, it will be beneficial. So can somebody tell me how many of you have studied insolvency law or have dealt with
No, ma'am.
insolvency
No,
laws?
no. Sorry,
Um,
ma'am. Deal from our end. Go in a simplest way.
So this will be the most simplest one. This is going to be two-way thing.
Thank you.
Okay, so once you know the
Hmm.
framework, I think the answer would lie to you where all you can put in technology. But to put in technology, you should know the framework. So anybody knows the basic framework of
yes.
insolvency law?
Good afternoon, madam.
Good
Actually,
afternoon.
I'm practicing advocate and have dealt with many cases under IBC. Mostly with respect to recently, I am dealing with a petition before Nagpur bench of Bombay High Court, where the IRP's rule is in question.
Okay, okay,
Yes.
okay. So good. So we have at least one co-faculty with me. So
It
to
would be
assist
very
me.
grateful of you to explain it in details, madam, because I would
No,
consider.
certainly, certainly.
Yes.
No, given the topic, I feel that 1 hour would be too less a time, but we will go by the overview. So anybody else who had some part or done some research on insolvency,
Yes,
maybe
ma'am. I
company
have
law.
also gone through this code. Actually, I am a company secretary too. So I have gone through this code. Along with it, my research topic is also related to the same. So I'm just
Okay.
going through it.
So what is
Yeah.
your research topic?
It's related to NPA, ma'am, non-performing assets, which I am
Okay.
relating with the current law for that. Yes.
Okay, okay, great, great. So
Yeah.
if you have already finalized your research topic, good. Otherwise, I hope that this session motivates you to take up a research topic.
I have already
And if you're
finalized this topic.
okay,
Yes.
no, for other members as well. Like I feel that if after this lecture, in fact, I would be suggesting some research topics. If your research topic has not been finalized, I will feel quite happy that I motivate you to take any research topic in insolvency law. Now, coming to the insolvency law, since I come from a commercial law background, let me tell you, in current time, when I had started commercial law faculty as a commercial law faculty, I used to feel very proud and I used to feel elite faculty, to be very honest. 15 years ago, 16 years ago, because everybody, wherever I worked, nobody wanted to take corporate law subjects because it is very technical, it is very dry. So you do not know how to make it interesting in class. So that was in criminal law, obviously, you will have all the type of cases. So all other constitutional law, you can go on debating. So corporate law was the area where faculties would be hardly over there. And then came the corporate law job. So all the students, they wanted to go for corporate law honors. So that time I used to feel that, oh, I am very elite, or less people are there in my crowd. Currently, if you ask me, I repent taking corporate law. Not because I don't like the subject, I don't like the challenges it puts me as a corporate law faculty. What are the challenges? That I don't have any course which is compartmentalized. I cannot just say I'm a company law faculty and then exclude myself that I would not be knowing what notification SEBI is coming up with, what notification RBI is coming up with. So what is important for us to understand, most importantly, and convey to the students that, see, you cannot be the corporate law person. Okay, you can have a basic knowledge of all the corporate laws, and then your analogy would determine how better a corporate law person you are, which will try to bring in the interdisciplinary approach between different corporate law courses. So I give a disclaimer that, see, though before coming in the class, I am coming with this latest notification, but do not rely on this notification. Maybe by the time you pass out, or maybe you're going for a next internship interview, please check on the website the latest notification, because these days all the regulators, every now and then, they are coming up with the new notifications. Another important challenge in competition law is most of the courses are a bit technical. So if you do not have a strong foundation, so if you lose that interest during building of foundation, you do not develop, or you develop the nuances of higher, or you can say corporate law 2 or other courses with much difficulty. So you have to understand the basics of capital structuring, basics of finance, at least this much you should study. But in entire all my corporate law courses, whatever I have taught, insolvency is one of the easiest and most, I will put it sweetest type of corporate law course which anybody can take up. Who does not have a knack for even corporate law subjects can take up. And the beauty of IBC is it has been written in such a simplistic and fluid manner that anybody can take that up as a novel, maybe read 2 or 3 sections and then leave it. So this is one of the interesting thing about IBC. And so we will start with IBC overview of different types of actions, because I have to relate it with technology, and I will try to give you overview of insolvency law. You all know that that is nothing new, that for long we have struggled for a quick insolvency regime, be it insolvency and bankruptcy for natural person, or be it insolvency regime for your corporate persons. And then over a period of time, through the entire procedure of SICA, so first we were in post, like pre-liberalization era, where it was not only that you have to take permission to start a business. During that time, if you wanted to close a business because it is running in losses, you had to seek permission from the government. So it was not like that, even if it is a private business, I can do shutter aaj upar kiya, kal loss mein hai, to I can pull down the shutter. No, government's permission was required to close down any industry, irrespective of private or public. And that time we had a socialistic form of governance of post-independence. And in fact, though we had a vision of socialism because we wanted to bring good to all, unfortunately that gave us a very bad name of Hindu rate of growth. So if you read economic papers, the lesser growth any country reflects, that would be between 3 to 4 GDP. So the term used is Hindu rate of growth, because what happened, we were growing very, very slowly post our independence, because we had socialistic notion, and government was taking control of all the businesses. So over a period with liberalization, we understood that government is not supposed to do business. Government is supposed to do welfare activity, and government can tax these businesses, earn revenue and do the welfare activity. But if government is intending to do welfare through business activity, that was the very ill-suited formula which has failed everywhere. And now we are most importantly realizing that. So what happened in Sika, as I said, companies were languishing year after year. They were making losses. And what type of relief we were looking for? We were looking for the relief, like if a healthy company merges with a sick company, so okay, we will give you tax rebate. You can carry forward their losses into your profit and you will not be paying the taxes. So all these types of rescue was being given in order to see that the companies were, or the industries were, surviving. And there was only one objective: to keep these companies going even after making sick or even having failed, was that they will lead to unemployment. Government never understood that time that, see, it is not about running a business, but it is about, see, stopping a business which has turned sour and then starting a new business. So work opportunities will come as and when you give a good business environment, rather than continuing with a sick industry and piling up of dues of workers along with the creditors due. So thankfully all this you can say marketing skills came up, and then there was ranking on ease of doing business. And we found that India was lacking on many parameters, even on contract enforcement and other. And one of the parameter where India was lacking in ease of doing business was that there was no early exit. So suppose today I wanted to stop a business, even a running business, there were a lot of government procedural requirement permissions before I could close down the business. So this was seen as a laggard. So government started for like one window clearance for the projects which were coming for industries. So that was good. But then they thought of that we should also give early exit. And it should be irrespective of whether business is healthy or business is sick. So they thought of coming up with the insolvency code on the UNCITRAL model. So already UNCITRAL model had given us a framework to every jurisdiction, a framework that you should have these characteristics in your insolvency law, which would be more specifically time bound, and it will be the closure of business. So easy closure of business. So easy legislative requirement, and in a time bound manner. So we came up with IBC 2016. And December 2016, when it was enforced, one of the few challenges were that whether, because IBC was created and then the condition was whether law of limitation will apply or not. So it was said there is a non-obstantiate clause. So whether it will override Limitation Act. So there had been plethora of judgments wherein we have said that Limitation Act is not any ordinary law where non-obstantiate clause of IBC would prevail. Rather, it is a, you can say, add-on law which tells the those people who come to for legal relief that please come in time-bound manner. So through Supreme Court pronouncement, it was said that the Limitation Act would be applicable, and then we amended and we also inserted in non-obstantiate clause that it will not affect the Limitation Act. So these challenges kept on coming up. There is interface of insolvency law with SEBI with respect to moratorium. So first, let me tell you what is the broader framework of insolvency law. So another interesting aspect is, if you are a corporate law faculty, you will know that there are two terms. From the time you would have read Solomon versus Solomon, you would have come across two terms with respect to creditors, that is secured creditors and unsecured creditor. Now here in insolvency law, you will find the mention of actually four types of creditor. So first two creditors have been identified as financial creditor and operational creditor. Now, these financial creditor and operational creditors are important term, wherein it is important with respect to filing of application. So who will have locus standi to file an application of insolvency. So they identified the creditors on the basis of financial and operational. And obviously the third person who will have the locus standi is the company itself, right? So we did not go by secured and unsecured. What type of finances you had given, that will determine. So in application, we have come up with the term of financial and operational creditor. Then we come up with the word when we form the committee of creditors, when we are sitting and deciding how to resolve the insolvency, this frame of this company, that would be decided by the financial creditor. So we have got a committee of creditors which would be only formulated by financial creditor, except when a company does not have a financial creditor or the financial creditors are related party. In that case, committee of creditors cannot be constituted, and only in those exceptional cases operational creditors would be forming the committee of creditors. And remember that entire insolvency bailout would be decided by committee of creditors. In fact, the adjudicating authority, which is NCLT, its work is very, very limited and similar to what has been decided in merger acquisition in companies law, that NCLT will only work as an administrative body, not an adjudicating body. Most of the parties administrative body, so they will not sit on the financial wisdom of committee of creditors when it comes to the resolution plan, acceptance of resolution plan. So if you recall your company law cases, from Tomco versus HLL to Mihir Mafatlal cases, any case you pick up, you will find that in previous regime, 1956 regime, High Court had very categorically said that the courts, they do not have the right to question the majority decision of the shareholders or majority decision of the creditors. What court is supposed to do is whether the procedure prescribed under law has been met or not, whether anybody has been suppressed or not. So only on the cause of natural justice and the due process, the high courts and currently NCLT can object the scheme. But if the scheme has been passed by the majority of the shareholders and the majority of the creditors, the courts will not sit and question on the commercial wisdom of those who are running the company. So we have the concept of majority rules. But court will only intervene when minority rights are hampered. That is all what is to be ascertained. Same principle has been borrowed and implemented here in insolvency, wherein adjudicating authority, which is NCLT, will not sit on the commercial wisdom of committee of creditors. It can only reject the scheme of bailing out the corporate debtor on two grounds. First is that the due process has not been followed. Whatever has been given in section 30, specifically 32, how the resolution plan should be. And second, if there had been any material discrepancy in the way the entire procedure was being conducted. Otherwise, NCLT will not say that committee of creditors, why did they accept this resolution plan? Why did they reject other resolution plan? Other resolution plan was better. And in one or two cases, NCLT had overstretched their jurisdiction and had, though they were right in rejecting the plan, but they overstepped and they said, you change your resolution plan in this manner. To which Supreme Court very categorically said that you were correct when you objected the plan and rejected the plan, saying it does not meet the statutory requirement of section 32. But you erred when you took a step ahead and you started suggesting what all should be there in resolution plan, and you started amending that resolution plan. Only committee of creditor has the authority to accept, reject, or amend the resolution plan. So you had overstepped your diktat. So this is very much settled. So we were talking about financial creditor. So when it comes to filing of application, when it comes to the decision on what resolution plan or who will be the resolution applicant, or during insolvency regime, how the corporate debtor would be functioning, what are the major financial constraints, all this will be dealt by the committee of creditors, which will be constituted by financial creditor. So you see, we have a regime. We shifted from SICA, which was debtor in possession regime. We shifted to creditor in control regime. Now, if you see, US is still going into debtor in possession regime. UK and India, they have adopted creditor in control regime. Now, what is the difference between these two regimes? The moment application is admitted, the control of the corporate debtor goes in the hand of these creditors, and specifically the committee of creditors, which is constituted by financial creditor. No more the management of the company would be part of the company. So it is, if you can correlate, it is somewhat similar like liquidation of a company in the Companies Act. So there will be, there a liquidator is appointed, here a resolution professional is appointed, and resolution, who can be a resolution professional? Any lawyer, any CA, any CS, any person with the your cost accountancy degree, who has passed the insolvency resolution exam, professional exam, which is conducted by IIP, that is Institute of Insolvency Professional Academics, which is under IBBI. So if you pass that exam, then IBBI will register you as a resolution professional, and then you can act as a resolution professional. So it is creating a new job employment apart from the liquidators who are on the official liquidators who are on the payroll of high courts. Okay, so you will be there notified by the IBBI. So what happens? Resolution professional will take control of the company, and if it wants, it may take 1 or 2% from the management and ask them to assist the running of the company if company is still a going concern. It may appoint new people, obviously everything with the approval of committee of creditor, that please appoint this lawyer, I need their help to run this business, or I want this accountant to help. So that may also be done. Important point is all this decision would be done by resolution professional with the approval of committee of creditor. So this is called creditor in control. And then the resolution plans would be submitted to the committee of creditors, discussed, and then it would be voted, and then the corporate debtor will be rescued from the insolvency proceeding, either one, by the acceptance of resolution plan, or there is no resolution plan and the company may go into the liquidation. So all this will happen, and the corporate debtor would be in control of committee of creditors. What was happening in SICA, or what happens in US in Chapter 11 insolvency? There what happens, even after the filing of application, management is with the company's management is with the current management itself. It will continue to run as it was running pre the admission of the application, and separate meeting of committee of creditors and all would be going on. So the creditors never take the control of the business. They only take charge of the insolvency process or resolutions that come up, and they decide whether they will be going with the insolvency bailout or whether they will be going for liquidation. But while all these parallel proceedings are done by the committee of creditors, who is managing the company? The management is managing, the directors and all, they would be managing the company. They will be calling the meetings parallelly of committee of creditors. So that is why that is called debtor in possession, and this is called creditor in control regime. So we saw that we could not use debtor in possession in SICA regime, so we shifted to this creditor in possession. So immediately with the admission of the application, the management falls in the hand of resolution professional, and they would be sitting in the sidewalks and just observing the proceeding going on. And if they feel that the proceedings are going to be not in the benefit of the corporate debtor, they have the right to apply, make an application to NCLT and objecting, which may be heard. So we have identified, now the question came in, we are saying creditor in control. Now, which type of creditor should we give this entire regime into? So they said, if you see the financial creditors like banks and all, they have the know-how of the finances, and they are best equipped when it comes to take a financial call, and their maximum stake is put in the company. And the operational creditors who have given credit for running of the business and all, they may not be having the financial acumen as these people from banks would be having. So that is when it was in the model law as well. They have identified financial creditors and operational creditors for the sake of realizing that they come with a financial background and giving them the entire business of insolvency and bailing out of the company. So as I told you, for filing of the application and for deciding on the resolution plan, we have identified financial creditor and operational creditor. But when it comes to the liquidation may dispersal of assets or even dispersal of assets in resolution plan, we switch to secured creditors and unsecured creditors. So you will see there is not much different in the waterfall mechanism that has been given for liquidation in IBC under section 53. It is almost similar to the company's law waterfall mechanism during the time of liquidation. So there you do not go by the operational creditor or the financial creditor. There the term used is secured creditor and unsecured creditor. So as always, secured creditors, obviously because they have a security interest created, so they have been placed above than unsecured creditor. So suppose I am a financial creditor, then I will be filing a section 7 application. If I am operational creditor, I will be filing a section 9 application. Okay, and then if suppose what company goes into liquidation, it will be seen that I am operational creditor, but I have taken security interest. So remember, during the time of creditor in control, I was given a subservient position. I was not part of committee of creditor. But since I am a secured creditor and company has gone into liquidation, so now that tag of operational and financial will be done away. I will be treated as secured and unsecured. So insolvency recognizes creditors. So one set of parties are creditors. Okay, so who will file an application? The other set of party would always be corporate debtor until unless corporate debtor has filed an application for its own insolvency under section 10. So you will always see the case law that there will be name of one party and then resolution professional and with the company's name. Because post initiation of insolvency, resolution professional takes the charge of the company. So he will represent the company in every matter, not the management, like it happens in company law. So coming back to the procedure, initially when insolvency was formed, the minimum threshold limit of default was 1 lakh rupees. Okay, why this was kept 1 lakh rupees? The 1 lakh rupees was kept in because we wanted to see, the insolvency regime wanted to say that I as a business person should know that when my company has come to a stage that now its revival is no more possible. So the entire principle of insolvency is do business, but do not fall in love with your business. So if your business is going downward and initially you have started, you are doing to revive it, but there would be a time when you will understand that there is no more revival possible, please exit out of the business. So insolvency code comes with one of the apart from few principle, one very basic principle, like you say, in Christianity they say hate the sin, not the sinner. Similarly, in insolvency, they said that if your business fails, I am not going to lower down your credit rating as an entrepreneur. Now, these days, these credit ratings are very important. You're holding a credit card, you will say you will have a credit rating everywhere, all over world. So if there is any default or late payment of credit card, that all will be lowering your credit rating. So similarly, what the government said that we are not going to rate your credit this limit lower just because you failed in business. Businesses may fail, even you are the best person knowledge wise, or you have run the business with good faith. So businesses fail, but what is important is early exit before spiraling down and accumulating losses after losses. So that is why what is important in insolvency is early detection of sickness and then time bound as early as possible completion of the insolvency proceeding. And third is, do not rate the businessman with the failed business, because failure of business, don't please come out of this assumption that failure of business takes place only because the management has committed fraud. The best example to see is many times it is market condition which leads to failure. So if you all are those who are from my era, you would be knowing during our growing up times we had that cassette, and then post that cassette we had that CDs, small CDs. Now Moser Bear was one of the big name in this CD business. Okay, and I remember I was even I had purchased and I had suffered loss. I was idiot, I was not tracking that share. So Moser Bear was one of the prominent name, and I'm talking about 2003 and all, when I was in Ahmedabad and I had invested, the prominent number one player in CD making. And then what happened? Suddenly this MP3 and all this technology came in, pen drive and all, and disk business was going downwards, right? So there was no way that you can blame Moser Bear management for sickness in the company. And there was no way that they could revive their business. So then in the meeting itself, SBI was one of the financial creditor, and we had that representative here in one of our programs. So the SBI representative, who was SBI was a financial creditor, suggested that we go into insolvency as early as possible because there is no scope of revival. So it is better we go for liquidation rather than wasting time in calling for resolution applicants and all. So what point I'm trying to bring in is that this entire insolvency says do not label the entrepreneur for a failed business. Businesses can be failed or can fail for many reasons. Okay, but what is important is come out as early as possible so that all the stakeholders, they face less loss. Now, when I have said stakeholders, who are the stakeholders in an insolvency regime? So you will see the first of all, the corporate debtor is the biggest stakeholder, and the most important stakeholder is the financial creditor. If you will read the IBBI, if you have interest in insolvency, please, or you're doing any research in insolvency, please refer IBBI newsletters. So they keep on updating. That is one good source of information of what is happening in insolvency. So if you see newsletter, in one of the newsletter I was reading, the financial creditors till now, they have taken the maximum haircut, and they are only able to recover like 2% of the total whatever credit they had given. So though when I'm discussing the framework, you will see the entire framework is towards the financial creditor. But unfortunately, what has happened till now, we are still resolving those cases which have come through CCA's time or which had been sick for quite a long time, and there has been accumulated losses. So what banks are doing through insolvency, they are also writing off their debts and balancing their accounts. So the biggest player in this is financial creditor. So we have creditor as one stakeholder who has been divided as financial and operational. And then we have the corporate debtor. Then you have a resolution professional who is doing all these businesses on behalf of corporate debtor and on behalf of committee of creditor. So he is the one person who is running the show during the insolvency proceeding. So there is a resolution professional. Then there is a information utility, which has been earlier, there was none. 2 years ago, they have made NESL as first information utility. Now, what is the work of information utility? They are nothing but the repository of information keeping. So let me first explain you the process of filing an application. So threshold was 1 lakh rupees. In COVID time, they took it to 1 crore rupees. I had done a research to find out that whether insolvency is being used as a, you can say, arm twisting method for recovery. Because from my personal experience, I can tell you, and I will not hesitate to even name the company. When I was in Ahmedabad, Reliance Industries, my husband, he's in L&T, the stockists would not go and do any business with Reliance Industries in Jamnagar. They would be telling to all these L&T persons, boss, kahin aur bhi bhej do, but we are not going to do business with Reliance. Why? Because Reliance was in the habit of withholding the current payment. This again I saw in when I was in Galgotia's university. Galgotia University would be doing the same thing. All those who would be giving them the operational credit, or the builders who had made their structure and all, this has been a general practice and very bad practice, that what I will be doing, suppose you are supplying raw material to me, so I will not give you payment of this month. I will only release payment when you give me next supply. So I will release this payment withholding your next payment. Okay, so that tomorrow if you leave, then I will even stop that payment. So these types of practices were going on when corporate debtor would not be releasing the amount. So the threshold, the moment it is 1 lakh, it was good for operational creditor that they will file an insolvency application. The moment corporate debtor came to know there is an insolvency application, they will immediately make the payment. Why so? Because what is the application process? Let us go to the application process. So if I am a financial creditor, then with the moment 1 crore, currently 1 crore limit has been crossed, this 1 crore would be apart, not only my principal amount, but my interest amount also. I will file an application with the proof to NCLT in under section 7. Along with my application, I will have to give evidence of the contract on which the loan was given, evidence of the payment or non-payment default. So we use word in the insolvency default. So I would be giving evidence that this was due, say 30 days ago, and suppose it was to be paid on every 1st of month, and on 1st of July it was not paid. So default has occurred. Now, the Avneet, when you're doing it NPA, so you should remember default and NPA are two different things. NPA only happens once the 30 days default has happened, and then bank declared that as a NPA, non-performing asset. But default occurs on the day when you were supposed to pay that, and banks wait till 90 days to declare it NPA. So your limitation period starts from the day of default, not from the day of declaration of NPA. So this is one very important factor, and there are umpteen number of cases that when the limitation period would be counted on the date of declaration of NPA or whether on the default. So the important point is on the day of default, if they have not paid and the principal and the interest amount comes to 1 crore rupees, I can file a application. Now amendment has been made. Not only me, suppose there is another financial creditor, my default amount is 50 lakh rupees, that person's amount is 50 lakh rupees. Now that takes us to the threshold of 1 crore rupees. So now with the amendment, I can jointly file an application against that corporate debtor that see default of 1 crore rupees has been met. So to financial creditor, they have given this additional advantage of going into group and making an application. This has not been given to operational creditor. So the operational, so in 7, what all documents I would be submitting? My application, default date, that on this day this was supposed, and evidences that first of all there was a contract, money was given, this was the date, and default has happened. Then NCLT has here only summary judgment it has to give. Obviously they will follow the natural justice. They will tell the corporate debtor there is an application. If you have to say anything, you can say, but this is just a summary judgment on the basis of the evidences given. NCLT will admit it. Also, one important thing is the financial creditor would be asked to give one name of the resolution professional from the list of name that has been put on IBBI. So during the time when NCLT has been given dictate of 14 days to go through this application and admit it, reject it, or send it for correction, during this time, it will also write to IBBI to find out whether that resolution professional is a person of good moral. There is no disciplinary proceeding going on against him. So once the admission, so this is 7. If I am an operational creditor, on the default of 1 crore rupees, I cannot go and make conjoint application. I will, what the rule says, section 8 says, I will have to first write to corporate debtor. I cannot straight away go like a financial creditor. I will write to the corporate debtor making a demand notice that see, I had supplied so and so as per my contract. My investment cycle or my credit cycle was supposed to be this. You have not made a payment. So this, on the demand notice, corporate debtor may remain silent or may dispute that. Okay, saying that no, sorry, I have not paid because I had already put a cash there, so there is some dispute. Now here, if there is a dispute between these two parties, NCLT has been given, because this is a summary judgment, NCLT has been given dictate, you will not admit the application. You're not going to sit and adjudicate, okay, whether both the parties are correct, which party is correct. Sorry, only you have to see whether corporate debtor has raised any dispute over the demand notice submitted by the operational creditor. And if you feel like corporate debtor may say, sorry, there is a case going on against you for this claim, so that is why we have withheld. So NCLT will not admit that application. So it should be dispute free, and the evidences should be talking about that. So so section 8 says raise a demand notice, wait for the corporate debtor to reply, and then under section 9 make an application with all these documents, and you may name a resolution professional or the NCLT may name it. So this is section 9 application, and corporate debtor for itself can move an application on 10. Now this 14 days and other deadline, if you will see the insolvency code at the end in schedule, you will see they have also framed 180 days the timeline given for insolvency proceeding, and then you can extend it to maximum 330 days. They have, for every you can say a cycle in that entire insolvency life, they have given a idle timeline. So they have given for admission of application 14 days, for start of insolvency proceeding and declaration of moratorium 7 days. So have step by step they have divided 180 days. That is just a guideline that resolution professional keeps to that target. So initially few cases had come up to ask whether these 14 days, 7 days, 90 days for admitting a claim, these are mandatory in nature or whether these are directory. So it has been settled by Supreme Court judgments that these are, though they say shall, 14 days may it will reply, but these are just directory. So you will see that the insolvency is not getting completed in 330 days. If you see the World Bank last data, you will find out 330 means within 1 year your insolvency proceedings should complete. But you will find out that India is still taking after this insolvency code. Earlier it was in SICA regime, it was taking 4 to 6 years to resolve insolvency. Now it is taking average is 1.5 years. Okay, so I will come to all these questions later on. Just let me give you the brief overview. So once application has been admitted, then the resolution professional will be appointed. And moratorium will be declared. What is this moratorium? Unique concept is that during the time of moratorium, none of the assets of the company will go out, and any litigation that is going against the company will all be stopped. So only that litigation would be allowed which is favorable for company. So the objective of moratorium is to stop depletion of this corporate debtor's wealth, because if there would be depletion, then there would be nobody who will come and give the resolution plan to revive this company. So during moratorium, now the challenge had been during moratorium, what type of proceedings will stop? So suppose corporate debtor and there is a creditor or anybody else, okay, there is a arbitration proceeding going on, it will stop wherever it is till the insolvency proceeding does not complete. If there is any civil dispute going on, that will stop. If suppose the question has been asked, suppose there is a PMLA case going on, will it stop? They have said no, it will not stop. If there is a negotiable instrument case going on against the corporate debtor, it will not stop. Why? Because these are criminal in. So moratorium will only apply civil proceedings, and they have all said only to those civil proceedings which have high chances of going against the corporate debtor, those will stop. Suppose I, as a corporate debtor against whom insolvency proceeding has started, and I have a claim against another company or another person, about which civil proceeding is going on. That will not stop. Why? Because that is going to add on to the corporate debtors wealth. Okay, so there is very clear cut on this. Criminal proceedings will continue, but civil proceedings which are beneficial for the corporate debtor will only continue, which are detrimental to a standstill. So moratorium is imposed. The moment moratorium is imposed, the resolution professional will give a public notice, and now it has been imposed that it will write everybody after taking the data from the corporate debtor who all are their creditors and tell them, please give your claim with evidences. So all the claimants, be it workmen, be it employees, suppose I am a workman and my salaries are due, I will be putting my claim to resolution professional with the evidence. There will be claim resolution professional will identify who are the financial creditors, constitute committee of creditors, and then this committee of creditors, what they will do, they will the resolution professional will be asked that you please go through the company's assets, make a list of asset and liability, that is called information memorandum, and then there will be a public notice that this company is going in insolvency. Anybody who is interested to and take this company, they may come up and give the resolution plan. So these are called resolution applicant. So resolution applicant, they will come, they will say that we are not disqualified under section 29A and we want to take over this company. Okay, so their characteristics would be identified by the resolution professional. They meet as given under 31, and as well as whatever extra committee of creditors they suggest, they will then share the information memorandum with the selected resolution applicant. Now this information memorandum, which has the entire detail of asset and liability of that company, about asset, they will have the knowledge of the who were the customers, suppose there are any IPR which is attached to that company. So all the business related information would be shared with those resolution professionals. When this is being done, it is somewhat similar to due diligence in merger and acquisition. There will be a confidentiality agreement that would be signed between the corporate resolution professional and those prospective resolution applicant. With this contract, that suppose your plan does not get accepted during the course and even after the insolvency, you reveal the confidential information about the corporate debtor. So that confidentiality agreement is signed, information memorandum is shared, and on the basis of that information memorandum, the resolution applicant makes a resolution plan. Now when this plan is made, the committee of creditors, they will sit and vote. On any plan, they vote simultaneously. Minimum 66% of the committee of creditors by value, if they vote the resolution plan or any plan which gets highest, that person will become the new owner of the, and the old management will go. We say this as a clean slate principle. So this is the CIRP process. If suppose there is no resolution applicant, the corporate debtor will say that please take this to liquidation, and the company may be going concern or it may be manner, and then this resolution professional starts wearing the hat of a liquidator. So this is in the crux, the entire process of insolvency. Now when you talk about technology, you see this is first of all this should be done in a time bound manner, and there is a lot of data that has to be collated. So first of all, if NCLT, because there is no need for one-to-one interaction at the time of filing of insolvency. So if NCLT is digital friendly, the application may be admitted online, so they may be used, and within 14 days the applications, because if they have a performer, have the proof submission, it can be done very quickly rather than manually, and it can be done by anybody. And online also, they can ask the corporate debtor to come and say if they have to say anything. And so technology may be used at the time of filing of application, but where technology can become more handy is resolution professional takes charge of the corporate debtor, because the entire, when you have to make that information memo, you should have the complete knowledge of the assets and liability. There is one very important concept of avoidable transaction. When entire this business is going on, one of the duty or few years done any fraudulent transaction, any undervalued transaction to a, because see, as a promoter I get to know my company
I think Kiran Rai Madam's voice is not audible right now. Kiran Rai Madam, we are not able to hear you, ma'am. Participants, am I audible?
Yes, madam,
Yes,
you're
ma'am.
audible.
Ma'am,
Yes,
you're
ma'am.
audible.
Yes, ma'am.
But
You are
I
audible.
think Madam is
Ma'am,
not.
you are audible, but yeah, Kiran ma'am is not audible, ma'am.
Yeah.
this insolvency proceeding whose diktat is to do it in a timely manner. So without technology, it would be very difficult to complete this or achieve that target of completing an insolvency proceeding in 180 days. So with this overview, I think I have already reached to my time. I would like to take the questions that are there in chat. Was I not audible?
Yes, ma'am, you're not audible for past
Yes, ma'am.
5 to 7 minutes.
Okay, but okay, so it, I think it would have been so where did okay, I'm so sorry. So where did I last end? You could have interrupted me.
Actually, information utilities, you have about the IBC and the technology.
Okay, so last leg, use of tech.
Yeah. Use of technology in the insolvency and bankruptcy program.
Again, you are not audible.
Again, yeah. Again, Madam is not audible.